Good morning, you're Travis Shoemaker. Speak up, please. And Mr. Shoemaker is currently on probation for the offense of injury to a child. That was a 5-year sentence that was probated for 5 years. There was a motion to revoke that probation filed. We were here previously. Mr. Shoemaker pled true counts 1 through 9, which include. Sorry, you're correct. Thank you. 1 through 6, and then 8 and 9. Just for the record, those include failing to report, failing to do community service, failing to do intensive outpatient treatment, failing to complete the battery intervention program, committing the new offense of domestic violence and false imprisonment in 2023 in San Francisco County, California. Has everyone had an opportunity to review that updated presentation report? Yes. Are there any additions or corrections, Collins? Mr. Hoffbauer? And this was just an open plea, correct? Was there an agreement?
Wasn't.
That's what I thought. Okay, Ms. Holmes, you may proceed.
Here's Mr. Shoemaker report to college information counting and living area in which he at some point had to be shot in California. Mr. Shoemaker explained the reason and why he was there, saying that he did contact probation to let them know that he was needing medical treatment because he was not getting the appropriate treatment locally, and so he decided to go down to the ended up in California. I think he does have family out there as well. One of the biggest issues in my meeting with Mr. Shoemaker is mental health. It is my understanding that he was extended so that he could participate in some mental health treatment. You feel that he does need to continue to have some type of mental health treatment. He is asking to be continued on probation so that he can get the appropriate treatment. In addition, maybe the court could consider the cognitive track of ISS as a means of helping to make you back on track, as well as if he does have that opportunity to continue to have the GPS monitoring, because we do know that there can be flight risks. And so I've explained to him for being agreement that this report gave him that opportunity so that he could get his mental health back on track and try to complete probation. That GPS monitor is appropriate. I also explained to him, because he had made a statement in regards to wanting to go to Hawaii. I personally told him that's not happening. And he then stated that he is willing to remain in Jefferson County and seek help or additional aid so that he can have the appropriate housing to remain in Jefferson County. Unless he is given some type of full trial. But Your Honor, Mr. Shoemaker is not the step forward to give him another chance to get his probation back on track and get his mental health.
So, and real quick, Mr. Hoffbauer, I probably can.
Yes.
Well, I just want to make sure. I'm looking back at the original pre-sentence report, and none of these issues are new issues. The mental health issues, the drug, that was all addressed in that original report, and the supervision plan included the requirement in the order that you enter and successfully and follow any services through mental. So you were given all of those opportunities from the beginning. So asking for them now, I mean, that was already done. And it's not just like you left it. I don't know what this health issue is that you think they can do better in California, but you went to California and obviously didn't get better because you committed the new offenses of domestic violence that, I mean, appear pretty serious. Mr. Hoffbauer?
Going to California twice. Went first time, brought back, the 11 first, 2020. Drive back to get clean. the court allowed him the extension of the term. That's when the mental health stuff didn't apply, and actually because California did.
You're right.
So, looks like maybe more.
I mean, so it's why. So, I mean, the original pre-sentence report, when he first got on probation, I said, let's do help you out, what you needed with services, then you left, and I, sometimes I look back at what I'll let people do, and I wonder what I was thinking. Because you went to California, came back, said I need mental health treatment again, and I said, okay, and now it's the third time you're saying that after we've had to go get you in California. Is there anything else, Ms. Ruiz, that's not in that updated report that you'd like to add? So, Mr. Shoemaker, anything else, Ms. Holmes? This time I'm going to find that you entered your pleas of true, again, to counts 1 through 6 and 8 and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. This is not a plea agreement. You have some limited rights to appeal. You could talk to Ms. Holmes about that, giving you that admonishment. Ms. Holmes, if you'll get signatures on that, and then get the bottom copy. I'm also going to hand you, Mr. Shoemaker, let's see, probably did this back in 2022. When you were initially placed on probation, I'm not sure if I did that back then when we started, but because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that written admonishment I provide you to make sure you understand the law. Okay? And once you sign that, we'll get you a copy of the certification, and then you can go back with the bailiff. Thank you. Thank you, Mr. Rose. Good morning, sir. You're Terry Rose. And in cause number 24, DCCR 1369, Mr. Rose is charged with first-degree felony offense of murder, and Mr. Roundtree, what is the announcement of Mr. Nichols' murder? Okay. Do you anticipate anything else coming?
I do.
Okay.
I would have thought I did believe that everyone this morning, and we released an opportunity to discover, but I can get tell and see now what I think.
Okay.
Notice the defense strategy here. Shift the focus from bad behavior to mental health. Smart move, but the judge isn't buying excuses easily. In fact, asking for GPS monitoring is basically admitting, yeah, he might run again. Not a great look.
Sure. So you can have a chance. So, realistically, for you to go through that, to get some other things involved if you need, what I'd like to do is maybe just a 60-day reset instead of a 30-day. That gives you time to go through everything, make any requests, Mr. Nichols. If there's something you need to go out to find, get that, and then I'll review the motions and get what you need to hopefully get a announcement maybe at that next one. Okay. Okay, so perfect. Thank you, Ms. Rose. You can go back with it later. All right, sir. Are you Christopher Wade? And will your client waive the formal reading of the indictment? Mr. Wade, in cause number 24, DCCR 0264, the state is elected to proceed on count 1 only. It alleges you committed a third-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from December 29th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computers and documents has your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Samuel? Do you fully understand? And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or a denial of naturalization under federal law? State sentence number 1. If admitted, is there any evidence that Mr. Wade is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive that credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read that written admonishment I provide you to see what devices qualify as a firearm. And if you have any questions about how long that lasts or anything about that, you can talk to me. All right? All right, good luck to you, sir. Hold on, Mr. Samuel. Good morning, sir. Are you Brandon Dodd? And Mr. Dodd, in cause number 24, GCCR 2418, you're charged with the first-degree felony offensive murder, and that is from October 14th of 2024. Your indictment alleges that you were previously convicted of aggravated robbery on February 22nd of 2005. And what that means is that it's... Sorry. Yes, sir. I've got it right here. So in addition, Mr. Dodd, the state has filed the appropriate motion that alleges that there, in addition to that aggravated robbery, you were also convicted of attempted Hobbs Act robbery in the United States Eastern District of Texas, Beaumont Division, October 16th of 2019. What that means is that if you are found guilty in the murder case and those two prior cases were true, then you would be considered a habitual offender, which means your minimum punishment is 25 years in prison, up to 99 years or life in prison. Do you understand? Then I have a plea bargain rejection here on the tablet that you signed with Mr. Reynolds. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 35-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial and found guilty and what your options are. You understand all of that. And Mr. Coleman, is there any other information or discovery that you anticipate you don't have? So I want to make sure you understand, Mr. Dodd, that after today, 35-year offer will not be accepted by the court. So if you're not guilty, go to trial, that's fine. If you change your mind later and you want to enter a plea of guilty, it would either be to something different than that, or it would be open to the court unless there is some new evidence Mr. Coleman and Mr. Reynolds weren't aware of today. Do you understand? And do you want to reject that offer and have your case at the trial? All right, and Mr. Reynolds, you've got everything. And
And of course, I've not seen the court file, and you made things, you inculpatory to show the thing, right line. So I would like to be able to do that before I march today.
okay. Okay, so I will go ahead and set it on the trial docket. If something about that information that you get once that's turned over to you changes the status of the case, just let Mr. Coleman know, let us know. We can make whatever change if there's any issues with regard to offers or negotiations based on it. Okay, all right, you can go back with the bailiff. Good morning, are you...
3 strikes, and you're still asking for probation? The judge is clearly fed up here. In legal terms, this is where credibility evaporates. Every new violation makes second chances sound more like endless chances.
Anthony Domingo? And Mr. Domingo was previously in court, entered pleas of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon and the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in each of those cases. I've received the pre-sentence report. Has everyone had an opportunity to review the report? Are there any additions or corrections? All right, Mr. Lewis, you may proceed.
when he was released from custody from DC, he had several strides for family sake before he retired and gave the job for what he needs to do. Unfortunately, some of his decisions for to leave the law and not help. He also was his that there was some drug issues that was going on. And from talking to nothing about it, anything somebody basically deal with while he was in PhD and after he lost several family members during that time period after he came home and just deal with the loss of and we believe that Prince's vision would have the structure and the vehicle they need to be able to address those issues, address any issues that will allow him not to switch and his attitude to see the state he how he feels with himself in going for training and cohesion and deal with allow there are things you should help him not be in a situation meaning that's what it is for him. He's given that opportunity. In that short time, he's made a lot of strides. Now, going back to the state, we're confident that still has out, still, have a life even after he's well with me.
Go ahead, sir.
Well, I think it's I was doing this, you want to work. I see building the mind, trying to keep it up. It's not home. I feel like, I ain't really caring about like, maybe like, all you need to do is want to get through. What bank? I'm not a bank person. I don't do this. I always been going to work, talking, helping my house, everything like that. Nope. You said it. I went home. I'll be not like you. I just want to be.
Was it your kid or another kid that was in the house that day? Okay, so I have no words. You barricaded, you were out of prison. You'd served 10 years. You grew up, more mature. You have an opportunity at freedom. You say you're not a bad person and you were doing things great, but you got out, you started using drugs again, you barricaded yourself inside a home with a gun with your 11-year-old so that the SWAT team had to come out? But you don't deserve anything. How does that even make sense? It is. It's very critical. You're right. Okay, so but you were inside the house with a gun. You didn't put something up against the door and barricaded. Right, okay, but still, you're inside the house with the gun with your kids. So we're not going to play semantics here and word games about what did and didn't happen. They don't know what they're walking into. They know that they probably received a call. Yeah. And that part's true, right? So they don't know what they're coming up on. Mr. Smith?
Yes, the ring gentleman is offer to use blood, attitude to weapon, threatening to kill. Terrible. Chad, I believe several chances at probation. He's never been able to successfully complete probation. He's on probation since 2011 until he finally got to work on all case in 2014. After he registered, he was in prison for 2 years and didn't make it 6 months before he ended his time. Chances of him actually being able to make probation are very small. And the fact that it could have been a lot worse, the police not being called, not just going in the house. It could be because of her, for the boy, and for the defendant. And no education, and probably limited to regular type jobs, always demonstrated unwilling to follow the law, to make himself at least a member of society. He's using drugs, and there's potential list of drugs. He's on alcohol,
And there it is. Probation officially revoked. 5 years in prison. This is the moment where courtroom mercy runs out. Remember, probation is a privilege, not a right, and Shoemaker just burned through every ounce of it.
Cody.
I'm sure having just got down he could have a firearm and threatened to with a firearm.
Was there some time when you got out of prison that you had to go to a halfway house? Because you had to do all your time? You did every bit of it. You know what that tells me? That tells me that you didn't act right while you were in prison. Well, I mean, most people make parole, you know? You didn't? Okay. I have no idea. I'm sure it's hard. I have no idea.
And Judge, if I may,
Yeah.
I think some of the things I was talking about was into raises your health and emotional health. Because a lot of it was, like I said, the things he did was locked here, most of what he came home to. So he made strides and everything, of course, having his state, which was getting himself. I don't think he can move down what I said. Once you see the damn guy, and Gordon was, not having this most.
Right, anything else? Mr. Domingo, I think you've had all the opportunities. The fact that you got out and immediately started using drugs, all the drugs, and yes. I know, but so you said here, though, that your date, it specifies on the PSI the date of your last use of drugs. So this shows that you last used alcohol April 23rd of 2024. Okay. That you last used marijuana February of 2024. So that was in between when you got out of prison and when you got locked up again. It shows that you last used Xanax March of 2024, which is in between that 6-month time. It shows you last used ecstasy March of 2024, which is in between that time. It shows that you last used codeine in between that time, March of 2024. So it shows that you didn't just get out and have a couple drinks and maybe smoke a little marijuana. You just got out and did all this stuff. And got yourself in this position to completely traumatize your own child. I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. And cause number 24, DCCR 1021, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 1022, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. Now, here's something, Mr. Domingo, that I don't normally say. You clearly need some help. I'm not going to say that you don't. If you're going to get your life together, it's up to you to get that help. But let me explain something also. Don't talk over me, because I'm not even sure I want to say what I was about to say. I'm not going to be respectful. If you can behave in prison, now I'm not saying this is going to happen, but there are things that can happen, potentially, where your attorney files something for me to review how you feel, and I consider probating your sentences and getting you back out of prison. But I can assure you of this. If you get to prison and act like you acted for the last 10 years when you were in prison, then you'll be there for the whole 8 years on these. That's going to be your decision. Alright? I'm handing you the trial court certification. In each case, it shows these were agreements that I followed, so you waived your right to appeal. I'm also handing you the written admonishment, regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible in Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Obviously, you know that information, but I'm required to. Alright, you can go back with the bail.